As Canada legalized cannabis, it triggered a wave of questions from employers. What do I do if my employees go for a toke during their lunch break? How are the rules around cannabis different from alcohol? 1 year after legalization, we explore what we've learned about cannabis in the workplace on this episode of the Employment Law Minute. Welcome to the Employment Law Minute, where we talk about common workplace issues and explore practical situations for both employers and employees. I'm your host, John Scholes, and I'm joined by Ottawa employment lawyer Alex Lucifero, partner at Samfiru Tumarkin LLP. Let's just clear the air, so to speak, right off the top, Alex. With cannabis now legal in Canada for a year, is it okay for employees, to use cannabis at work?
No, it's not, John. Just because cannabis is now legal, it doesn't make it right for employees to be able to use cannabis in the workplace. Cannabis should be treated in the workplace, John, just like alcohol is. An employer should have clear policies about alcohol, cannabis, any kind of substance abuse in the workplace. It shouldn't be tolerated at all. Companies should have drug and alcohol policies in play that clearly delineate what the rules are with respect to that, banning it from the workplace. There are some exceptions when it comes to cannabis with respect to medicinal purposes, which we'll get into in a sec. But no, I want it to be clear to all employers and employees out there, you are not allowed to use cannabis in the workplace just because it's otherwise legal, and doing so can potentially cause some problems.
Is there other ways that an employer can maintain a drug and alcohol-free workplace?
There absolutely is, and I just referenced the policy, and that's the primary way to do it. You want to have a policy in place that very clearly delineates that alcohol and drug abuse is not tolerated in the workplace, what the repercussions are if an employee is found to be abusing those kinds of substances in the workplace. You also want to carve out in a policy like that your policies with respect to medicinal marijuana or medicinal, drugs in general, and what can be accommodated with respect to those kinds of medicines, and what can't be tolerated. So health and safety concerns, even if you're having to deal with medical marijuana, health and safety concerns have to be addressed and prioritized in the workplace. You cannot put other employees in jeopardy just because one employee, for example, has to use medical marijuana. So items like that can be laid out very clearly in a policy. Having said that, John, you want to make sure that you actually put your policy into practice as well. You can't have your policy just sitting on a shelf in your HR department. You want to make sure that you're implementing those rules and those policies as much as possible.
A year into legalization, is it treated differently in the workplace, medical marijuana versus just normal cannabis?
It absolutely is, yeah. You have to distinguish as an employer between the recreational use of marijuana and the medicinal use. Recreational use could be completely banned. That's completely something that you don't have to tolerate. Medicinal marijuana is a little bit different. As an employee who's been prescribed medical marijuana by a doctor, you may very well, as an employer, have the duty to accommodate that kind of prescription. Now, again, you can't allow as an employer that employee who's taking medical marijuana to put other employees at risk. So if there's a level of impairment there, and that person is in a safety-sensitive position, you can't allow that employee to continue on with their job while they're impaired. But certainly in a situation where there is no health and safety risk, you may have to accommodate someone who has been prescribed medical marijuana. So very clear differences between the two. One, you may very well have to accommodate as an employer. The other can be a completely zero tolerance policy.
And I know quickly, we've talked about this on other shows, if the employee feels like they're not being accommodated for medical marijuana?
If the employee is not being accommodated, even when it comes to medical marijuana, you may very well have a claim against the employer for a human rights violation. As an employee in that situation, you need to get employment law advice. You need to contact us, speak to one of our employment lawyers. We'd be more than able and more than happy to guide you through that process. If it's the case, John, where someone with a medical marijuana certificate or prescription is being treated differently because of that prescription, being discriminated against, or even if they're let go for that reason, John, that employee is going to be owed severance. They might even be owed additional amounts because of the way in which they've been terminated or the way in which they've been treated. And quite frankly, even if when it comes to recreational marijuana, even kind of one very minor offense may not be enough to terminate an employee who has been found to be breaching a policy. You've got to be careful as an employer. Even in that kind of situation, that employee may still very well be owed severance. And again, that severance is going to be significant. It's going to be a significant outlay for the company, and it might be very significant for the employee as well.
Good stuff, Alex. We're going to have to leave it there for now. Are you experiencing an issue in the workplace? Contact us now. Help at employmentlawminute.ca. The number's 1-855-821-5900. Go to employmentlawminute.ca. You'll find past episodes of the show, resources for employers and employees, as well as contact information to help you find practical solutions to workplace problems. employmentlawminute.ca. Thanks for watching. Until next time.